Thanks for coming tonight. Again, we do have a really great speaker tonight. Jen Matthews is a member of our planning committee for St. Louis Mini Law School, so she is going to go ahead and introduce our speaker.
Thank you, Jen. Good evening, everyone. How we doing? Great. I was here the first night. I don't know if any of you remember that. That was only a few weeks ago, but it is my absolute pleasure to introduce Seth Crompton to you all. He's right over here. He is a partner with the Holland Law Firm, which is located in the city of St. Louis. He's here to discuss class actions and mass tort actions. Some of you might be thinking, what in the heck is she saying? He will explain all of that. He's been on both sides during his career. He started out as a defense attorney and now represents plaintiffs in these mass tort actions. He is nationally recognized as a top 100 trial lawyer, and he appears in state and federal courts around the country. And he's obtained large verdicts and settlements in these complex litigation cases. So he will tell you more about his background, and I won't bore you any longer. So without further ado, Seth Crompton. Thank you.
All right, so make sure you can hear me okay in the back. That's where I sat in law school, by the way, in the absolute back. So I'm going to move that so I don't have two microphones going. So today we're going to talk about something that you see a lot about, but you probably don't know. There's a lot of assumptions and I assume a lot of misinformation out there. So we're going to talk about class actions, and I assume everyone in here has at one point in their life or another either gotten a little voucher in the mail that says you may be entitled to compensation if you had this product or something like that, and there's been a settlement, and you can send that in. And the second thing we're going to talk about, and those are generally what you consider a class action. We're going to go all the way through. And the second thing we're going to talk about is what's considered a mass action. And again, it's something that you commonly see in different forms, one of which is I had the perhaps unfortunate circumstance of being stuck in a doctor's office one day, and I think there were maybe 6 or 7 consecutive lawyer ads on TV, and a lot of those were due to pharmaceutical cases, and they're saying, did you take this drug or use this device? And those are considered mass actions, and they're slightly, at least as the law views them, a little bit technically different. But we're going to talk a lot about them. There's something that's kind of forefront in a lot of policy issues. There's a lot of political discussions that surround these types of cases and the ramifications from them. So we're going to talk a little bit about that today. So first thing, briefly about myself. So I grew up in a small town in southern Illinois near Carbondale, which is, I don't know if anybody know where that is. There's a university down there. And so my family worked in a variety of industries, railroads, mining, did some trucking, construction, all of that. Mostly a lot of union workers and things of that nature. I've done, some people who, it's interesting when I talk to when they become a lawyer, haven't really done, their family, their mom or their dad or whatever was a lawyer. They've always been a lawyer or something like that. I did some of the worst jobs you could ever think of and the most disgusting things that anyone should ever have to do as a teenager to help my grandfather's business. So he asked me one day, what do you want to do when you get older, when I was 15 or 16, and I said, I don't know what I want to do, but I do not want to clean out the gutters at your house. I don't want to clean out the toilets at your shop. That's all I know is what I don't want to do. So from there, I ended up in law school ultimately here in St. Louis. So I started out doing what's considered a corporate defense, civil defense firm. I assume you've heard a little bit about, obviously there's essentially two. There's the criminal system, and the civil system. And the civil is obviously the lawsuits, when one person's suing another or suing a company, or the company suing them or another company. So I've done civil defense. I did civil defense for the first, maybe 5 years or something like that, representing various companies and different types of cases. And then in about 2010, I switched over to doing the other side, which would be considered a plaintiff's lawyer. And the plaintiff's lawyer is the person who represents, in many of our instances, we have a kind of a varied practice, but we represent individuals who are suing a company or something like that for something that went wrong, essentially. And so, we also do, as part of that, we do injury cases. We still, to this day, which is something I'm happy about as growing up in the family, we still represent the injured railroad workers when they get hurt. And usually when they get hurt, they get pretty seriously hurt, either lose legs or worse many times. And so we have an injury practice. We also do some environmental litigation over the years, and we also do business. But probably the main thing that I do for the firm is class actions and mass actions, as I've described them. So that's what we're going to talk about today. So first of all, the rules for presentation. I'm very informal today. Jen made me wear a suit. I normally wear jeans and Guns N' Roses t-shirts, but she told me that was not appropriate for you guys. So please feel free to interact, raise your hands, discuss. I like that more than me just standing up here talking, and if I don't see you, I apologize. I'm not ignoring you. In talk through this, I like kind of the interaction and the back and forth. It's kind of, we do appellate arguments from time to time, and, you'll have situations where you're talking to the panel of judges, and you just get this stone wall stare from everyone in the room, and you're like, well, I don't know. All right, I'll just get through this, and we'll see what happens in a couple months. So, and other times you'll have it where they're just firing questions back and forth, and you get through absolutely none of your presentation. So please feel free anytime, ask questions, interact, discuss. This is for you guys, not for me. So, a class and mass case is different than what is considered a traditional type lawsuit. So a traditional lawsuit is something that you see sort of every day. And it's not, and I'm not trying to, they can be complicated, but simple idea is someone gets rear-ended in a car accident, they're hurt, and they end up suing or making a claim against the person who rear-ended. That's pretty straightforward. Obviously, it can have, like I said, I'm not saying that it can't be, but for the most part, it's pretty straightforward. You have one defendant or one plaintiff suing one defendant. You can also have more kind of complex, scenarios of traditional or typical type lawsuits. Those might be, a business suing another business. I got an interesting call the other day, so I can't tell you who, but so a fairly public persona or character has a lot of tattoos, and so I got a call from the tattoo artist, and the tattoo artist, said, "Hey, look, those are my tattoos." In the company that he's doing the work for currently is using these, basically it looks just like him in some video games and other things like that, and she's like, "Those are technically my art." And I said, "Well, that's interesting." And I said, "I haven't done something like that," but the interesting thing about it was, I don't know if you guys have ever seen the movie The Hangover 2. And in that movie, there's a tattoo on a guy's face that basically mimics Mike Tyson's tattoo. And the person who designed that tattoo, Mike Tyson's tattoo, actually sued and won because of the tattoo being his art. And so we got, but again, that's more of a traditional lawsuit. One person suing another person. Same thing happens in a lot of medical malpractice cases. Again, they can be complex, but again, you have a person dispute with a doctor or something like that. So the class action it will start with it's a unique procedural device recognized under the law. It's not, the law was created, it was basically for two parties to solve a dispute. And over the years, it became apparent that sometimes that scenario just wasn't possible. So basically what essentially happens is you have one person who, and we're going to talk about some examples here in a minute. But you have one person who, or several people, one or two, just depends how you do it, represents kind of a larger group of people. It's usually a smaller damages that the suit probably would not be brought otherwise. You know, if you walked into a lawyer's office and said, hey, look, I bought this product for $15 and it doesn't work at all. It's terrible. It's absolute junk. The lawyer's going to say, well, I understand what you're saying, and I'm not here to disagree with you. Problem is I don't know how any of us, including you, is worth our time and money to pursue $15 over a bad product. But at the end of the day, there was 5 million of those products sold. It's still a bad product, and it was still on the market. So a lot of times the cases are aggregated over the small damages. So the question is, you know, how do these come about? So I'm going to give you a few examples of cases we've worked on that a few of them I'm particularly proud of. So Remington Rifles is the first one. So, and you know, obviously this isn't political. I own guns and rifles myself. It wasn't about that. Remington makes a Model 7, approximately, you know, Model 700, there's 710 and other ones, a rifle that contains a certain trigger mechanism in it. And unfortunately, what this trigger mechanism has a defect. And over the years, quite a few number of people have been killed, because what will happen is, and I can tell you one story in particular, what will happen is the gun will just fire. Either on, and even if it's on safe, it will fire no matter what, or even if it's off safe and your hand's not even near the trigger, the gun will fire. So an example of that is a guy who called us about this case. He had 2 guns, one in the back seat of his pickup truck, one in the floorboard of his pickup truck. And his kids were standing beside him. Fortunately, they didn't get hit. But the one in the floorboard he never touched, and it was on safety, and the gun went off. And there was no reason, no one touched it, the gun went off. And when people hear that, they say, well, there's no way. Go ahead. It is. So that's my case. So, I think one of the other lawyers from our team spoke on it. But yeah, so the gun went off, and it hit him in the leg. He's fortunately okay. Unfortunately, his kids weren't stricken. But so, you know, he's going to have his own personal injury suit. But the bigger picture is, as we looked at it, is, okay, this trigger mechanism, this trigger mechanism is a $70 fix. And Remington had denied that there was ever any problem with this dating back to the 1980s, from when other people had been hit over the years. But this is a $70 fix. Remington is a huge company owned by a very well-off hedge fund or private equity firm at this point. I think they are. And so, you know, someone comes in and says, okay, we're going to have to, you want to take on this behemoth that is Remington, but how do you do it for $70? I mean, an expert alone to testify that this is a gun defect would cost $500,000, so you can't do it. So that's one way that cases are aggregated. We looked at it and said, okay, well, maybe we could just get the guns fixed. They made, since like 1940, I think they made 7.8 million of these rifles. It's the biggest selling rifle in the history of the world. And so we thought, okay, if we could just get them fixed, we aggregate the claims, maybe eliminates this scenario. So that's why we did, because you couldn't do a one-off case against Remington for $70 to fix the guns. Now, you could do a personal injury case, but again, that's not a class action case, and you would have to wait to be injured. And what we were hoping to do is so that the injuries would stop, essentially. So we aggregated all the cases together, filed suit, and it was approved in Kansas City, and it's actually pending. There was an objector who filed, saying that notice should have been wider. But long and short of it, it's in the 8th Circuit Court of Appeals, waiting for determination by them. So we'll see. I guess we'll see here in a few months what happens. The second case that we did that I thought was pretty cool was called mortgage modification. There was a program, I'm going to say maybe 2008, 2009, following the housing crisis. And it was called the Home Affordable Modification Program. And every big bank in America participated in the Home Affordable Modification Program. And in theory, it sounded really good, because a lot of people, as you may recall, and hopefully none of you were in the circumstance, but were underwater on their home. They essentially owed more than the home was worth or that they could afford to pay, because years before that, the banks were just giving out credit. You want money? That sounds great. Doesn't matter where you work, what you do, what your bank account says. Here's your loan. And so a lot of people ended up underwater. And so what HAMP tried to do was to take their current financial situation, compare that to their mortgage, and say, okay, here's a mortgage that you may be able to pay. And what we're going to do is put you in a 3-month trial plan, and if you make these 3-month trial plans, we'll make it a permanent, that was the temporary version of it, we'll make it a permanent modification. And sounds great in theory, and unfortunately, most people who ended up in the trial plan either ended up in the trial plan forever or never got to the permanent modification. Hence, there were tons of foreclosures. People owed, incredible amount of money, of back money and fees, because these programs were never complied with. And the one thing that we were able to do in our settlement was, at least for that particular bank, was to get the bank to comply with the initial agreement. Because again, you couldn't do these individually because for the most part they're very small. I mean, they weren't small, they're obviously someone's house, but depending on the amount, if they were only a little bit behind, it just didn't make financial sense to spend $10 million fighting a bank when over one person's mortgage. It just would not have worked for anybody, and that person would have probably owed the lawyer more than they ever owed on their house in the first instance. So we were able to get that resolved and get people basically the program that they were supposed to have in the first instance, which could never have been done on an individual basis. It put a pressure on the bank to fix all these people's mortgages, because on the one-offs, they were just randomly, they just foreclose upon people that, they couldn't get through to talk to anybody. So, but as an aggregate whole, people got to keep their house. The next thing, which I thought was amazing, sometimes I'm actually amazed at some of these things, is the bank overdraft fees that we did. So, say you have $100 in your bank, and you charge, I'll just make this up, you charge $30, another $30, now you're up to $60, you should have $40 left. You charge 2 more $10, now you're up to $80, you have $20, and you make a mistake and you forget, and you put something big on there that kicks you over. You make a $50 purchase or whatever, and it kicks you over. So, as we all understand, and as it should be, when you make that mistake, unfortunately, you incur the wrath of the bank, which means that you're going to get docked for an overcharge fee and several other fees associated with your account being overdrawn. Well, what the banks figured out to do is, in order to maximize overdraft fees as is actually a very lucrative area within the banks. Fees are actually various fees are actually huge money makers for banks. So what the bank figured out to do was, what we're going to do is, while these are pending, is resequence your transactions. So what will happen is say you did make the mistake at $90 and made a $90 purchase. So the bank resequenced it. So what the bank would do is, now you have the first purchase being your $90 purchase, your second purchase, your $30, your second $30, your fourth was $10, and your fifth purchase was $10. So now you have 4 overdraft fees. So, which they made a lot more money from that. Like I said, I'm not saying it's right, but I was like, who would even think to do this? So you end up with 4 overdraft fees. But at the end of the day, again, an overdraft fee could have been as low. Some banks only had 4 or 5 overdraft fees. And again, if you walk into a lawyer's office and say, look, they took $5 from me, I'm like, I'm sorry, but you're going to have to go ahead and just pay that $5 and, move on with your life. But when you take $5 from 20 million people, at a minimum, there was more than that. That starts to add up. And that allows for basically the remedy for people to join together to fight a bank to get the resequencing, as they called it, to stop. So another one, interesting one, was mine subsidence insurance. Again, I grew up in coal country in southern Illinois. So mine subsidence is a thing, and I didn't even know what it was called, but I saw it as a child. So when coal is being mined, coal is mined through seams. And they just follow, wherever the seam goes is where they go. There's no path. It's just followed through. So it's this weird kind of winding route. So what happens is, when I was little, I noticed some people's houses would sink through. And they would just fall into the ground. And then all of a sudden you would see them propped up. And what was happened was the mine company had tunneled, of course, underneath where their property located. And eventually, due to shifting, rocks, the earth and all that stuff. Their house sunk. And the weird thing is you could have one house that sunk here. This house is fine, this house is fine, this house is fine, and 2 streets over you have another house sunk. There was no rhyme or reason actually behind it. So Illinois came up with a pretty good program actually because the insurance companies, the homeowners insurance companies were like, no way, we're not insuring you for mine subsidence. So Illinois created what was called the Illinois Mine Subsidence Program, essentially. And so what that meant was it was essentially kind of a rider that had to attach to your policy in the 30 southernmost counties. And they actually kind of reinsured it without getting into the details of how the logistics of it worked out. But the insurance companies essentially had to offer this coverage. And so what happened in that case was once you have a subsidence event, you can't have a second subsidence event, essentially. I mean, you could, but while it's ongoing, while your house is sinking, you can't have another subsidence event. So your house is sinking. Well, what happened was okay, my house sunk. This is awful. I make a claim. Well, okay. Well, that's fine, and your claim's pending, and they essentially had to let your claim pend. Basically, had to wait till your house settled and figure out what the damage was. Well, what the mine subsidence insurance company continued to do was sell them a premium every year for this insurance, even though they couldn't make a new claim. The claim already existed as it was. So they're getting essentially free premiums because you couldn't say, well, sorry, new claim in 08, because they're going to say, absolutely not. That's the 07 claim when your house sunk, same one, but they're paying premiums. So again, $130 premium, $200 premium a year, obviously wouldn't have lent itself to doing it on an individual basis. It had to be groups of people who brought this together. The next one is a Volkswagen wiring harness. I did not know this existed. Does anyone know what a wiring harness is? Okay. What is it?
It's working price where what you put in the car is higher than you wire it up.
Absolutely. And so
it's a lot of wires.
So a defect in this wiring harness, as you know, or a problem with it, or it ripping, shuts down essentially a lot of the the electrical components of the car. So what Volkswagen did, for some crazy reason, was decide that, we're selling this Volkswagen VW, the margins are pretty slim, and what else they did, where else they saved money, I don't know, but I know that for some reason they decided that instead of using a normal wiring harness, they used a shorter one, because when you're selling mass production of cars, this adds up over time, this thing. So what would happen was people, as the gentleman suggested, people's cars, you couldn't roll down your windows, or, the trunk wouldn't pop, or, all sorts of crazy things. And a lot of them went in for other repairs that they may have paid for over the years, because no one exactly could figure it out. So it came out that this was kind of the problem. But again, this is, to fix these wiring harnesses is, depending on the dealer, I saw $170 to completely fix it, all the way to, maybe $300 on the very, very high end, depending if you went to the Manhattan VW dealer. But again, it's a scenario where no one's going to take, a small case. It's just impossible to litigate a small case against an international company like Volkswagen, and it had to be done as an aggregate class action. So the next one we'll talk about, I also thought was pretty interesting, is called forced place insurance. So I assume many of you have had a mortgage on your house. And so hidden in that mortgage agreement is a little thing called a forced place insurance clause. And no one knows what that is until it gets forced upon you and you get your insurance bill. So in there, the bank has because it's, until you pay it off, you don't own your house, technically. The bank owns your house. So the bank puts a little clause in there to protect its own investment, which is, and it says essentially, if you don't pay your homeowner's insurance, we're going to put our own homeowner's insurance on our investment. And so what happened in that case is the woman we represented She owned a home in East St. Louis, and in fair estimation, her home was probably worth $30,000 or $35,000. Well, she got behind for a couple months on her mortgage. So in the meantime, the mortgage insurance, or our homeowners mortgage, I said homeowners, I'm sorry, the mortgage insurance, which is what insures the bank's investment, cancels the one that was part of her thing. So they put a new insurance policy on her $35,000 home, insured for $270,000. So obviously, there's a slight discrepancy in how much her insurance premium was in one instance versus her insurance premium is in another instance. And again, we had to aggregate the claims because they had to be done. They just had to be done together. But that was just another example of how we took a bunch of people with the same problem and tried to get them with a solution. And we'll talk a little bit later about criticism. And I don't think she was a wonderful, wonderful woman, her and her husband. And I don't think she would. She was deposed. She was never going to say, "Sure, I wasn't at fault. I missed that. You're right. That's wrong. I take responsibility for what I did. I missed that payment. We got behind. I'm sorry. We're working to fix it up, and we'll fix that." What the unfairness is, okay, no problem. If you're going to do this, which I understand the bank has a right to protect its investment, just get the same policy. It doesn't need to be insured for 9 times the amount. And what ultimately came out is there was kind of a kickback scheme between the banks and the insurance company as to why they were doing it. And, so that's how that was the reason that ultimately came behind it. So the last one is just some general examples. One of people's biggest investments that they make throughout their life is obviously their home. And we do a number of building or construction products. And a lot of those over the years have involved shingles, siding, decking, and things like that. I can tell you on one case in particular, the shingle expert for the class action, all told on our end, all in, the bill was over $1 million for this guy to say why the shingles were defective. I mean, the house itself, some of these houses, the roof on them was, it was $10,000, $15,000 roof, but no one and these shingles were defective for a lot of people. But I can sure tell you that of the, a couple 100,000 people in Missouri who had this particular shingle, not a one of them would have said, you know what, that makes sense. I'm going to pay $1 million just for this expert alone to figure out, to test, because they all had to be formulaically tested. The plants had to be inspected, all this stuff to say, yeah, you're right, and please fix my, $15,000 roof, $1.5 million later. It just it doesn't make any sense. So that's kind of the genesis of how I suppose these come about. So please. So the one we settled in particular was against Chase. There were various banks. Unfortunately, a lot of the cases did not turn out very well, but we were fortunate that we were able to get a settlement. All of ours were consolidated in federal court in Massachusetts. And interestingly, while around the time we argued our class certification, the Whitey Bulger trial was going on up there. I don't know if you guys know who that is, but he's a famed or infamous, I suppose, mafia guy in Boston that had been on the run for decades, and they found him in San Francisco. So it was quite it was crazy what was going on in Massachusetts when we argued that. Sure. So my firm, I can think on only 1 or 2 times, and they were very, very targeted instances where we advertise for something. We don't particularly advertise. Frankly, most people, especially with the mortgage situation, would call often a lawyer that they knew, and then they would call us and say, hey, can you do anything with this? Sometimes people will see that we do general consumer law, some general consumer stuff, and they'll call us. And I'll tell you, the biggest actual driver is we filed against a shingle manufacturer in Missouri. We filed a case, and our name is on the case. Well, people get on the internet now and see if other people are having the same problems and things like that. And when they do, you usually get a copy of the petition. Usually is somewhere online, and so people say, "Hey, did you file this? I have the same problem." So it often comes about, kind of organically in that way. I mean, I've been told, I've got a lot of calls over the years and stuff. I didn't even know what was going on, and it took a while to kind of unwind. The mine subsidence thing took me kind of a little while to figure out exactly the scheme behind that. So. Mm-hmm. Mm-hmm. So they can be pled in different ways. So sometimes you can have a state only for all members of that state. And it's increasingly difficult, but often when it's settled, you end up with a nationwide class. Now, if someone generally files a case in federal court, saying here in federal court in Missouri, they will generally try to plead a nationwide class of all people. In state court, there were some amendments, I think in 2005, it was called the Class Action Fairness Act, and basically you can't sue. You could perhaps if it's the company's headquartered in that state, but you generally can't just sue a company anywhere and allege nationwide status just in a state court somewhere. You generally have to file those in federal court, but a lot of times. So the short answer is that you're not always protected, but it just depends on how they chose to particularly allege their complaint at that time. Mm-hmm. I'm generally, yeah.
So that was in another state.
Yeah, it just depends. Like I said, I don't know how they pled that exactly, but they may have pled it as to cover everyone in the United States, and they may have pled it only in the state. And generally, what I would tell people is if it's not pled if it's only for some lawyers maybe only bring an Illinois class action, for instance, that doesn't protect anyone else's rights anywhere. Now, when it settles, if they settle at Illinois, what do they want to do? They want to get the whole, for the most part, people want to get a whole thing done at once. So, yes, sir.
I'm following up what you're saying. I was thinking about this Equifax thing.
Mm-hmm.
Where all of a sudden, but there's other, like TransUnion, there's others.
Mm-hmm.
But how do you find out if there is class actions? Would it apply to the other unions? Are you like free credit for the information that's stolen? It's good forever. I mean, your birthday's the same, your social security.
Right.
It doesn't end.
Yeah, so what happens generally is if there's, I'll call it a mass crisis of that nature, sometimes, huh? No. I use that phrase generally. So what happens if there's kind of a crisis of that nature, I suppose, is, as it's filed, I'm pretty sure it's filed on behalf of a nationwide class of everyone who is wrong. But there'll tend to be a bunch of lawsuits, and usually you can find them all over the internet because there's all sorts of websites and people that track these things. But, it's not necessarily going to be against the other credit unions because obviously the breach wasn't with the credit unions. But it's a great example of the class action works because, again, you don't really know. Your data could be stolen 20 years from now. You may not be damaged in terms of money out of your pocket right now, but there has to be a way to fix this scenario. And the one thing that some of the companies try to do is to head off the problem. And one way to do that is, hey, we're going to give you free credit monitoring for a year. Sign away that you can't bring a suit or you'd be a member of a class. And some people want to do that. That's obviously their choice. Some people think that's not what I'm interested in because I could have problems years down the road. So, in this day and age, data breach cases are actually very common. There's a lot of them out there. It's actually kind of concerning how many, it's, even beyond Equifax, how often this occurs. Yahoo had a huge one that everyone heard about. The case almost was in the midst of settling. And then during the course of discovery, they figured out that instead of, I'll make this up, like 5 million accounts were hacked. It was like 50 million accounts were hacked. So everyone's, back to the table on that. But yeah, I mean, I guess the short answer to your question is, look, if there will be on some of those things, there will be some programs you can take advantage of. I guess it's just a matter of personally weighing your rights. I can tell you on the shingle cases, for instance, people will get offers and say, all right, well, the shingles are bad, right? If you don't want to go through this, we'll give you $1.25 for the 30 shingles on the left side of your house that you think are messed up. Some people say, all right, whatever, I don't want to go through this. Some people say, well, they're not going to match. What about these other shingles? And, and that also doesn't cover labor or anything else. So, it's just one of those things. There are programs out there, but generally you waive your rights if you essentially settle with the company. So, sure. Go ahead. Yeah, go ahead.
What's going on with the Johnson baby product?
So the talc, I actually have that on there. We'll talk about that in a minute. So that's a mass case. We'll get to that in a minute. Yeah.
I think based on
which ones?
the overdraft.
So the overdraft all settled. The mortgage modification case we did settled. Some of them did not. The reason behind it, I mean, at the end of the day, when I chose to do this side of the law, I suppose, I mean, some things, this is just one of those things where I thought that, can you do good for a big number of people? And so we ended up taking those. Sometimes the cases don't work out. I can tell you a lot of cases where we've spent money on that didn't work out, and there's no one to pay us back. That's, we lose on those cases. And so in some of them we win. We'll talk a little bit about class action fees and stuff like that. So I guess in my experience, it kind of evens itself out. But, we chose, or at least the people on my side of the bar, chose to represent people who, or businesses, have had something wrong happen to them. And unfortunately, that's the nature of the game. We don't get paid by the hour. We get paid if we win. And so, we got to win. So another thing, a different way, is called a mass action. So mass is a little bit different than class. So essentially what happens in a mass action is you have a whole bunch of people with individual suits that are sort of consolidated for efficiency. But at the end of the day, they all may not have the same damages or the same exact problems, but it makes sense to consolidate them together. One of the most common forms of those is, of course, pharmaceutical drug and device cases. Also sort of toxic exposure cases to chemicals and stuff. Like we did a case, I don't remember the name of the town, but we represented basically an entire town in the northwest corner of Illinois, or Iowa is kind of right on the border. And the whole town had a tainted water supply. And and there was a lot of issues from it. A lot of people had cancer and stuff like that. But everyone had different kind of issues from the water supply. And so when we had the case was against the oil company that had the pipelines going through there because they leaked over the years. So that's an example of people grouping together to do a case, but it's not one product that they bought. They all didn't buy, shingles or the same shingle or the same consumer product or something like that. And the other way to do it is, environment, the mass action, we're going to talk about these, is environmental or mass disasters. The BP oil spill is one of the biggest mass disasters in history. And there were some class actions that arose out of that, but for the most part, people had, if you owned a shrimp boat down there in New Orleans, you certainly had different damages than someone, who owned a swamp boat and was driving people through the swamps. And so, it essentially arose and fall, I guess, for lack of a better word, on its own merits. So, to your question, let's talk about a couple examples of mass actions. So, let's talk about GranuFlow. So we did a case. GranuFlow is a dialysis, basically chemical formula. And people were having, they'd get off the day, and most of these people are obviously elderly. They had, some of them very, very elderly. They had obviously kidney issues, and they were on dialysis. And there was a specific mixture that had to be done, but the specific mixture was actually due to kind of a person's own internal, acidic levels and things like that. Actually had to be calibrated to that specific person. Well, what Fresenius was doing was, here's this machine. Here you get hooked up, and we don't really know that people aren't really trained that well, and we're going to cut it close, but we don't exactly know the right exact amount. So some people would, not surprisingly, have a heart attack within 24 hours. It would kill them. And so, but these people all had their own individual cases because it was all unique to them. The formula was given to them. It wasn't the same to everybody. So that can't be in class action. Everything has to be the same. But they had the formula that was given to them was a little bit different. Their damages were a little bit different in the sense of maybe they didn't pass away, or maybe they suffered for a few days, or they didn't suffer for a few days. So it created a unique scenario that you couldn't have done as a class. But we grouped the people together because what essentially happens is again, pharmaceutical companies, very difficult to take on an individual case. So if we group a bunch of people together, you can split the cost. $1 million for an expert divided amongst 1,000 people starts to make the metrics a little better than divided amongst one person. So similar to that is Risperdal case. So Risperdal was narrowly approved for essentially schizophrenia, actually. And the maker of Risperdal thought, well, we can make a lot more money if we expand the use of this product. And one day so it was originally only approved for adults, schizophrenia in adults. And so what the manufacturer did was say, okay, well, one way we could do this is to start having our people come out, getting doctors and our salespeople to come out, and certain doctors, we pick them to tell people you should give this to kids that have ADD, OCD, just other kind of disruptive behavior type disorders. Well, it wasn't approved for that. And so obviously you sell a lot more of it, but it wasn't approved for that by the FDA. And unfortunately, one of the huge side effects of this, especially in boys, was breast growth, it was gynecomastia. So you would have, and I've seen them, you'd have 8-9-year-old kids who look like they have, like developing breasts, essentially. And that was something that, came out about that was never disclosed, because I don't think too many people would give their kids that if they knew that was going to happen. It also happens in device litigation. Infuse was a device, a back device. And so the concept of Infuse was kind of a combination of a cage and a bone morphogenic protein. And what this was supposed to do is if you have a back surgery off, sometimes they'll use a cadaver bone or something, or your own hip bone to as part of the fusion. Well, what they did is they came up with this called this bone morphogenic protein that was supposed to basically help your back fuse itself within this cage. Again, it was a pretty good idea for what it was, and it was approved by the FDA for a certain type of surgery. I may be mixing it up, through the back or through the front. I don't remember which one as I sit here, but at one level, basically your lower lumbar spine. Well, what Medtronic decided was, that's pretty good. Maybe we should see if we can go ahead and market this for wider use, such as in your upper spine surgeries. And unfortunately, what you ended up with is what amounted to, unfortunately for a lot of these people, was essentially what amounted to is concrete being poured down your spine. And what happened was it would grow. And so instead of fusing, your spine looked like this. And what happens when these bones, they grow into your nerves? So we had people paralyzed and things like that. But again, you can't do it as a class action because everyone had different surgeries. Everyone has different reactions. Everyone has, different problems from this. Some people, fortunately, were not paralyzed, so you have a whole spectrum of events. So the last one, I'll do for you real quick, is called the transvaginal mesh. It is the largest mass tort in the history of the United States. A lot of women have this after having kids. Things obviously aren't, move around, they sag, things like that internally. And what this is basically try to help hold like internal organs in place. And there was tons of complications from it. It didn't take. There was complications that wasn't disclosed. And again, these women, it's actually currently pending against, 7 or 8 pharmaceutical companies. All are in, some's in West Virginia, have banded together to try to litigate these cases, because otherwise they just couldn't be done on an individual. They just couldn't be done individually. Yes, ma'am.
What happens to parties that are necessarily ones manufacturing products that they're recommending? The doctor says, oh yeah, there's this big problem online, you should try the transvaginal mesh or Assure, and then it turns out, oh, this is a bad idea, and some problems. They also get prosecuted for malpractice?
Some people try it. Generally speaking, as far as, sometimes you have to make some choice in your litigation strategy to who you're going to go after. And medical malpractice cases are very, very difficult to prove, especially if the doctor can say, hey, look, and Infuse is a great example. So to answer your question, so what happened at Infuse was in 2004, Medtronic decided we're not going to publish the results of our studies of what I told you about in the Spine Journal. Instead, we're going to have our people write our own articles in the Spine Journal saying this is totally safe. They actually, the DOJ actually got after them in 2012, and it was the first time in the history ever of the Spine Journal that issue 8 years later was retracted because of that. So what happens is you essentially, the doctor can say, look, I relied on the medical literature to some extent, and that's to some extent the doctor's disadvantage of that. Now, do you have another issue if the doctor, once the Escher stuff comes out, that there's a problem with it and the doctor prescribes it? Perhaps then you have a different issue. But again, the short answer is you could, but it doesn't always make sense. And sometimes, frankly, from my perspective, I always like, Escher, for instance, I would like the doctor to come in and say, hey, look, of course I wouldn't have given this to her had I put this in her, had I known that, So I don't, and he's certainly not going to come in and say that if he's being sued in the case. He's, it's just a different dynamic. So the long and short of it is yes, it happens, but it's just a matter of litigation strategy. I personally don't tend to do that, but it just depends on the case. I think, yeah. Correct. So devices, so one of their biggest defenses that they always try to get out of, get the case dismissed, is called a preemption defense. And preemption means, well, the FDA said it was okay, so it's good. And setting aside my feelings on how that process generally works, the problem often is as I mentioned in Infuse, yeah, the FDA said you could use this at L spine level 2 to L spine level 3, through a posterior surgery. You, however, have used this through a different surgery at these levels that was never approved, and there's a reason it was never approved. So, that's kind of that's always the first, we file a case, the first thing you always get on a device case is a preemption that, kind of a toss up the hands. Well, the FDA said we could, what's the problem? So that's on the other hand. Sir?
Where does something like mesothelioma and asbestos fit into this? Because I thought that had already been decided that the government will expose had a fund or something that was paying that should still be added.
So
Have you been exposed to asbestos or have you had mesothelioma?
yeah, and so, probably I have like a slide that's like 2 from here. Might have been better to do it. But asbestos was kind of the precursor to what you consider your mass torts today. Asbestos, was one person suing a bunch of people who made asbestos-containing products. They would have been around. And so what you see is that it's not the government that pays them. So several companies over the years have went out of business. The insurance company essentially put the money into a trust. It's called an asbestos trust, essentially. And so what they do is if they have a claim against the company that is in that asbestos bankruptcy trust, they'll do that. But then they can still, some companies aren't in that trust, so they can still pursue a case against some of the companies still that aren't in that trust. So that's kind of why you still see it going on. Correct. There's still viable lawsuits, and there's different exposures, and there's different defendants, and not every defendant. Some of the big ones are in there, like you would expect, like John Mansville that made asbestos insulation are in the trust. But some of the ones that may have had it on their property, for instance, like a Shell refinery or something, they're not in the. If someone worked at Shell their whole life, they'd have a case against Shell. But Shell's not in the trust that the bankruptcy trust essentially. So. You had a question? I think you understood.
I was just curious. You said it's hard to win a malpractice suit against a doc, yet all you ever hear is the outrageous fees they pay for malpractice insurance. Why is that? Who's taking care of who?
So that's a tough question. I know the answer to it. Let me try to how to word it the right way. So the question is. You always hear that it's very, very hard to do a malpractice case, but why are the doctors also complaining about the fees or the rates, right? Okay, insurance rates. So, the interesting thing in Missouri in 2005, they had significant medical malpractice reform that wiped out, I would say, probably 90% of medical malpractice cases. Most times now, medical malpractice occurs all the time. It just sometimes it's not discovered, or sometimes can't be pursued, just because of, again, the dynamics of the situation and the caps on it and things like that. So your question is interesting to me because the interesting thing is there's 90% less lawsuits, and what the pharmaceutical company response was to that was. Or the insurance industry's response to that was okay, well, yeah, but on average, the verdicts are higher. Well, yeah. Of course they would be, because you're only getting the 10% biggest cases that are ever filed, but you've knocked out these. So they say, oh, well, if you get sued, your risk of, of this or whatever, but they're characterizing these catastrophic 10% as kind of the whole, when that's really not the case. So, I always thought maybe the doctor should push back on that, but I don't know. Question?
I was kind of curious on this asbestos and
Okay.
Manufacturer. As far as I know, suppose somebody did in that situation.
So there's been a lot of discovery over the years at a lot of facilities, a lot of construction sites, and a lot of stuff that, generally speaking, and other people have had the disease. Generally speaking, you can start to figure out what was on those sites. It's not always easy, but as kind of I appreciate it, you can figure out what for some big hospital that was built 40 years ago. Over the years, there's been discovery and documents exchanged as to who were the contractors there and what products were put in. And what, at this point, everyone kind of has a pretty good idea of what products contained asbestos. It's just a matter of figuring out what products were there. So, yes, sir.
These big companies, when they develop products, I don't think that they're intent on harming people to begin with, and as they go along, they have indications for these products, and as they go along, there are side effects, there are adverse reactions, but I think that many and most of these products, as they are indicated, they work, and they help people. And yet the impression that I'm getting here is that we're demonizing these companies because they risk bring products to market that would help people. Sometimes they do, sometimes they don't. It's a risk factor. And it's like every time that there's something that happens in usage of these products, that the legal system's after these companies.
So I see your point, and like I said, we'll address some criticisms at some point, and that's one of them. But to your point, to go why we're here. So, what your point is, and we'll use Infuse as an example. So to your point, the product was developed for spine surgeries. And again, I think it, could have made some sense. You didn't have to have a hip bone or a cadaver bone or anything like that. Well, what wasn't disclosed was why it shouldn't be used at your C-spine level, for instance, and the catastrophic effects from that. And so they knew about, generally what the evidence would show was, in a lot of these cases, and not just that one in particular, they knew about these things, but if you disclose all that, you're never going to sell it. You can't get it sold to the medical community as a whole. You can't get doctors to buy in and use it if you have these catastrophic events. So what repeatedly happens in these cases is some of the worst events, which would destroy cells and never have them used again, are called adverse event reports, are not reported, are kept in South America. I mean, I'm not making that up. Kept in South America at a company down there where they're then shipped to the German company, and then they're then scrubbed back to the FDA. So the short answer is look, I don't think if you took a drug and they said this drug is going to make you fall asleep, and you fell asleep all the time, I don't think anyone, at least from my side of the bar, would say, yeah, did you have a case? If you took a drug that made your arm fall off, and before coming to market that they knew that your arm was going to fall off and they didn't disclose it, because who in the world would ever take this drug if your arm fell off? I think that's a little bit of a different story. So, question?
Somebody probably knows that probably. They consider being on both sides, well, also be worth it. Not sitting on the trust, they know different sides of cash flow last for 100 years. Are they paying taxes on it?
Yeah, I think the question essentially was, is there a cost-benefit analysis done of, what happens? And I think the answer, as I understand it, at least from what I figured out, is generally yes. And, the Ford Pinto was a great example. Everyone knew that the Ford Pinto, or I shouldn't say Ford knew that the Ford Pinto, if it was hit the right way, would blow up. But you do the math, what's the chances of this? And the chances are X percent. Okay, well, you know what? Yeah, we may have to settle $200 million worth of cases, but we're going to sell $2 billion worth of cars. So, I mean, that's what came out in the Ford Pinto case in 1970 something. So, does that happen? Yes. Yeah.
One question, I have a comment as well. I get irritated when I see commercial on television, class action suits for some of the meds, because what you're supposed to be done is, I unfortunately take a lot. I always get the literature, and it tells you all the side effects of things that happen. So they should have that knowledge instead of factory prescribes it. If there's anything about the patient to be discussed, it should certainly go through them. But I understand that they don't get the money from the doctor. They have to go suppliers or the pharmaceutical. But that's always irritating. I know that information is out there. And my question, on the transformational mass, there are a lot of companies and they're different, they're made from different. So does the class action for all of them, or are there?
They're specific manufacturers and they're unique. And again, it's a mass case, and so it's unique to that particular device, because different ones have a little bit different issues and stuff like that. So, real quick, and then we'll take a break. On the talcum powder cases, again, that's an example of a mass action case where people have different effects from using talcum powder that wasn't disclosed, to them, and they're not having cancer from it. Ready Roundup is Monsanto's one of the biggest selling products. It's been shown to cause non-Hodgkin's lymphoma, and the allegations are similar to that around talc. Is you've known that for 30 years, and I guess my opinion would be is I've used it. I probably wouldn't have used Ready Roundup had I known what I know now. And finally, again, I mentioned the BP oil spill as an example of a mass action, one of the biggest ones ever. So it's about 7:30. let's take maybe 5 or 10 minutes and we'll finish up.
And I'll let Seth get back to it.
All right. So switching gears just a little bit, we'll get to some of the more, just a little bit, and I'll be able to move through this pretty quick, just some of the technical pieces of class versus mass cases. Again, a class action is generally everyone bought the same product, for instance, as, you know, they have the same damages. You know, the product didn't do as they would said, and essentially everyone gets the same kind of relief across the board. It's not really used in personal injury cases such as drug or device cases because kind of the highly variable nature of the cases. Mass, as I mentioned, you know, kind of in some is, you know, the injuries and damages are often different, and kind of each case, and you know, when you have a mass settlement of, say, involving a pharmaceutical drug, there's a whole range of outcomes, and there's also a whole range of settlements. So everyone's kind of falls on their own, on the merits of a case. Just like if you got in a car accident, it would, you know, fall on how bad, you know, if you were rear-ended, you know, how bad are you hurt? What was the, you know, what was the liability? How fast was the car going? What kind of car was it versus what you were driving? Those kind of things. So the relief is unique to the individual in the mass cases. So, you know, again, and I've hit on this kind of through the question and answers, which I really like, by the way, no matter which side of the fence you're on. So why do it? Why do it this way? And, you know, again, in class cases, the damages are just often too small to do it. And it empowers individuals with a claim to kind of have their day in court that would otherwise never happen. The mass cases, again, the damages can be larger. You hear about them. That tends to be all you hear about is the bigger verdicts. And, you know, but again, the costs are prohibitive to bring these suits, and there's just no way to, except in very, very rare instances, to justify them on an individual basis. So the plaintiffs are able to share cost expenses across the board against a defendant who, in some of these companies, often have unlimited resources, and, you know, actually factor into their SEC reports litigation expenses and things like that. And it's, you know, it's one way to bring kind of mass accountability for a device or product that should not be on the market, and, you know, the ramifications of having that device on the market. So class action, we're going to kind of flip back and forth. So class action kind of proceeds in 2 steps. So the first thing you have is the class certification phase. So basically, the class certification does not determine, it's very difficult to get a class certified, but it does not determine, or it's not supposed to determine, who's right on the merits. The only thing that happens at the initial stage, and sometimes it could take 4 years, 5 years to get to this, is whether or not the case can proceed as a group, and we'll go through some of the elements here in a minute as to how we figure that out. But the determination in that instance is made by a judge, not a jury, because it's a matter of law for the judge to decide how this case can procedurally go forward. And if the judge does decide that the case should be certified, then discovery and briefing on the merits of the case occur, which is where you would determine liability, fault, and that's ultimately can be determined by a jury. There's state class actions. It just depends where it's brought at. But yeah, it's a determination by the judge. So there's kind of 2 pieces. We'll just do Missouri. Missouri rules of civil procedure actually are modeled after the federal rules of civil procedure. So essentially what I'm going to tell you here today is essentially how it works in the federal system as well. So the first thing is called numerosity. The class is so numerous that joinder of all members is impractical. What does that mean? That sounds like a whole bunch of nonsense. Basically, you can't have a class action if there's like 3 people in the class. So, you know, generally speaking, you know, 100 people will certainly do it. You know, there's some cases where there's 40 or 50 maybe, but most of the time you have 100. I mean, you know, in many, you know, we have a case involving a common hand soap product. And, you know, I mean, I think they sold like 75 million units of those. So obviously we have more than 100 for the numerosity for that one. It's generally not a fight. The second question is kind of the precursor to the big fight, is questions of law or fact common to the class, meaning can 1 or 2 issues resolve this whole case. So one way to do it, one way to think of this is say you have a product that advertises it's 10 horsepower, but it's not really 10 horsepower, it's 4 horsepower. Can determining whether or not this is 10 versus 4 horsepower resolve, is it common to everyone? Would it bring a resolution to the class as a whole? Arguably, if I was doing that case, I would say yes. Determining whether this horsepower is correct is common to everyone here, regardless of why you purchased it, what you used it for, or anything like that. It's common to everyone there. The third part is kind of part and parcel the same thing, is kind of typicality, the claims or defenses of the representative parties. This goes to the person who's the class representative. Basically, in a kind of a silly example, they can't, if you're suing on behalf of, X product, they actually had to have bought that product and have the same problems that someone else in the class is having with that product. And believe it or not, it doesn't always happen. And the fourth part is kind of goes to the class counsel, us, and the people who are the class representatives, meaning, are you going to adequately represent the class? Are you going to produce some documents, bring your product in for inspection? Are you going to take a deposition? Those kind of things. And that's where you'll hear, sometimes you'll hear in a class settlement, you'll see that, Susie Smith gets what's called an incentive award for bringing this case on behalf of the class, and like extra $5,000 or something like that. And that's because Susie Smith is the one who, went to the lawyer's office, brought the documents in, sat through 7 hours of deposition, from the other side, and then everyone, she gets the same relief. She just gets a slight bump or award, for lack of a better phrase, for going through that, assuming the case settles. If it doesn't, then unfortunately Susie Smith has wasted some time of her life. So the second part of this is the part 2 part, is where the real fight, I suppose, comes in. You have to satisfy all of the ones I just mentioned to you, and you have to also satisfy one of these 2 tests. The one has to do with this first kind of second bullet point has to do with injunctive relief, meaning telling the defendant they can or cannot do something, that they would have to put out maybe corrective marketing or corrective advertising. The real fight comes from the third bullet point, and it says the court finds that questions of law or fact common to members of the class, as we discussed, predominate over questions affecting only individual members. So this is where the fight essentially comes down to in most of these cases. Are the big picture issues overwhelming or predominate over kind of the small picture issues? And it's not a very simple scenario, and again, it's where the fight comes in on most of these, because the way these cases are typically defended is you try to point out this person is unique, or this product, for instance, would have been used in 100 different unique ways, and you can't do this in a class action. So that's kind of the way to defeat it. So there's a few other pieces to it. Interest of members basically doing it as a class versus separate cases. There was a big case involving, I don't remember the product off the top of my head, but Monsanto, for instance, in I don't know, this case is probably 4 or 5 years old. It was a crop, and I don't remember which one. And they tried to do it as a class action, and the court did not certify it as a class action because the farmers, each individual farm or corporate farm, however they were set up, had pretty high damages from the product. And the court said that, look, these farmers, given their damages and given that, what they're out and all of the stuff and, the changes in their yield and all these kind of things, individually controls this litigation more so than doing this as a whole group. And the case essentially got converted, for lack of a better phrase, from a class action when it was not certified to a mass action of everyone, of the farmers essentially banding together in a different procedural way to kind of to deal with the products with the crop. And again, I don't remember what it was, but
don't they have to establish that harm has taken place? Financial or personal harm?
Sure. So you have to. So that goes back to the predominancy issues that we talked about. So you have to show that that there was harm, for instance, and you also have to show that there is a damage model based on that harm, or that basically correlates with the harm. You can't just have a damage model that doesn't have anything to do with the harm. So yeah, that's part of the predominate. So one of the things you get argument is, the damage model, for instance, doesn't really is not amenable to being done as class as a whole. So yeah, it comes. I kind of glossed over it, but yeah, that comes out in that format through the damages. So. Same thing, desirability, undesirability of concentrating in a particular forum. Some people could say, hey, it doesn't make sense for us all to be in court here in Missouri. Most of the people are from Texas, and if we're going to do this, we should do this all in Texas. And, that weighs against class certification. And finally, difficulties likely to be encountered in management of a class action, kind of goes to the practical realities of how do you deal with notifying these people, dealing with it, because again, it's not an easy process. How do you go about procedurally dealing with the fact that there's, millions of consumers from every city and town across the U.S., and how do you deal with that? So the kiss of death, as you might suspect, for class certification, it would be things along the lines of what you've heard about of kind of mass cases. The nature of the injuries people suffered are different, extent of the injury is different, causation issues different amongst the people. There's individualized defenses. So learned intermediary, somebody brought up the doctor earlier. So a learned intermediary defense, for instance, is a defense that the doctor knew. It's a complete defense to a case that the doctor knew what the problem was, that there are potential risks associated with this drug or device. This was explained to you, and the doctor made the decision to go ahead under your particular circumstances to prescribe the device. And so that is, first of all, it's unique. You could never do a class action, but it's also a complete defense, meaning the company would win under those circumstances on a mass tort case. So, and otherwise, the biggest issue is always trying to poke individualized issues through, so the class can't be certified. Procedure for a mass action. So unlike a class action, there's no separate stages of litigation. If you recall a class action, first thing you do is class certification. If you get it certified, you then proceed to go through the merits as a class altogether. Mass is obviously more follows the path of a traditional lawsuit. It's obviously much more consuming, expensive, complex given the high stakes involved, but it's similar to, and there's obviously some of the discovery, meaning, deposing people at the company, medical experts, collecting documents can be done grouped as a whole together, but at the end of the day, it still kind of follows this path of, a person's case gets tried after they they produce some documents, each side deposes their particular witnesses, and then we have a trial ultimately. And the interesting thing that occurs in a mass case as opposed to, like a car accident case, say if you had a trial and, I guess you can have an appeal, but essentially once the jury renders a verdict, that's where we're at. Obviously you can appeal, but for that portion of the case, it's over. Mass, obviously if you tried, I don't remember the numbers, but I know in that transvaginal mesh case in Virginia or West Virginia, there's something like 80,000 people in that. Well, so you have one trial. Well, there's also 79,999 people left to go essentially after that one trial. And so what they call in federal court, it's called a bellwether trial. And bellwether trial is both sides get to pick a couple of cases that defense picks their cases that they think are representative of all the people that have had this same injury. Plaintiffs pick their cases, and they're separately tried. And sometimes, you never know. Sometimes the defense wins the plaintiff's picks. Sometimes the plaintiff wins the defense picks. Sometimes the plaintiff wins them all. Sometimes the defendant wins it all. But what the real goal of that is okay, look, we would all, our grandson's grandson could never try your granddaughter's granddaughter could never try 79,999 mesh cases. It'd be going on for eternity. So what they do is these bellwether trials start to establish sort of the parameters of, okay, if this case is going to resolve as a whole, so that, so what range are we looking at? Are we looking at 0 to, $500,000? Are we looking at 0 to $50? Are we looking at 0 to, $10 million? And so essentially it's kind of a test case that both sides are supposed to pick cases that, kind of adequately represent what's going on. Yes, ma'am. So there was a decision.
Can you repeat the question?
Oh, sorry. So the question was, can employment, harassment, discrimination cases such as those qualify for mass or class actions? Did I get that right? Okay. Sorry, and apparently I've done a terrible job of repeating the question, so I apologize to whoever has to watch this video after this. So, so the answer to that is it used to be yes. A few years ago, 5 to 6 years ago, the Supreme Court came out with a decision involving Walmart, where there was kind of a class action involving employment practices and some allegations regarding how they treated their employees, I suppose. And the court said, no, you can't do employment class actions. So, are there some employment class actions? They're called wage and hour cases, where generally everyone was kind of skimmed a certain amount, and or mostly what happens in that is someone who's not really a management employee was paid as if they were a management employee, but they didn't get their overtime that they actually should have got. But generally, the answer is no. Most employment cases these days proceed individually. Now, you could, I suppose, if you had 10 people from the same company that experienced the same problem, you certainly could try to bundle them on one complaint and file it. How that would work out, the defendant may move to sever them out into different trials for different legal strategy reasons. You could try it, but you certainly couldn't do it as a class action. You could try to do it as a mass, depending on the circumstances. I don't know how it'd shake out, but you could try it, I guess is the short answer. So we went through a bunch of these, and I'd like to leave some time at the end. So class action criticisms and responses. So one of the biggest things I hear is people say, well, I got $150. The lawyer's got $1 million. I don't really think that's fair. Now, I understand where you're coming from. And my response to that is a couple-fold, I suppose. Number one, it's a comparison of apples to oranges. You have to realize 10 million or 5 million people got $150. And if you were to have a car accident case and, I'm making this up, you got 10 grand, the lawyer would get, if the contract was for a third, because, you would, on a contingency fee, you would get a third. Well, what you're comparing in this scenario is one person's recovery, not the class recovery, to the lawyer's fee. So, and many times, if you were to actually use that kind of 1/3 metric in like a car accident, the lawyer's fee is very, very small to actually the overall metric. And the second thing is, I tell people, this is kind of an amusing anecdote. So everyone, when you graduated law school, had to take this course called Barbary. And basically, Barbary had cornered the market on teaching us all how to pass the bar. And thankfully, I passed the bar, and most people I know did. Some people didn't. So years later, Barbary gets involved in an antitrust case because they've so cornered the market, and there's some stuff that they did that, helped them corner the market. And so this case ultimately settles. And I don't know, I was probably making a 4 or 5 year lawyer at that point. And I got a check for I don't know, we'll say Barbary books cost us, I'm making this up, $1,200. I got a check for like $300. And I guess my response to somebody that says, well, that's not fair. I got $300 and the lawyer got $1 million. And I'm like, well, yeah, but you got $300 and you didn't do anything. So, I was pretty happy about it. But no, in all seriousness, though, I mean, it's an apples to oranges comparison. Again, kind of the second point is only benefits the lawyers versus lawyers. The lawyers that do class actions, to some extent, there's only so much the government can do, and so I always at least viewed us as who does from this side as sort of a private attorney general, and the law is very strict on what can be certified and what can not be certified, and cases that you think would just absolutely, should work as a class do not work. So, I always viewed us as sort of private attorney generals of, enforcing what stuff that wasn't enforced. Another thing people say, well, I got a coupon for, to go buy something. For the most part, those aren't illegal, or those are not allowed after 2005 with the reforms. Sort of the unfairness versus reality and accountability without getting into sort of too much of the political nature of it. Some people say, oh, it's just not fair to the company to have to, deal with these claims on an aggregate basis. That they should be, that they can deal with them individually just like any other lawsuit. And I get that, but the reality, as I found it, especially, is most often they're not dealt with. And for instance, in shingle cases, they're said, well, I'm sorry, we don't see anything wrong with your shingles. And, it forces a level of accountability on what is often a smaller consumer product that, again, no one's going to take a $4 overcharge draft fee case. I mean, they're just not going to do it. I mean, a third of $4 is $1.33. And while I do like to do something that, makes Mama Crompton proud, $1.33 just isn't going to send my boys to school. So, last piece, and again, these are kind of legally created things beyond the elements that we talked about, is ascertainability. And that means, how do you figure out who's really in this class? This is a hot button issue, right? How do I know that, that this person who says they purchased, whatever, this hand soap, for instance, actually really purchased this hand soap? And the argument is always there's no way to ever know that. Now, in some cases, it's very easy to know. For instance, the mine subsidence cases, the forced place insurance cases, we know who you are because you bought this and there's records that you buy it. The real difficulty comes down is your basic run-of-the-mill consumer products. And, there's been some decisions on both sides of this. One of them says, there's no way to do it. Others say, it's a split issue. And other courts say, look, I mean, if you're going to do that, you just as well take class actions off the book. There's just no sense in having them because you can never certify a class. So what we do is, can you produce a receipt? Are you willing to sign a verification under penalty of perjury? There's some various, ways to deal with that. But again, the court's kind of split on how you deal with it. Mass actions, criticisms and response, innovation, which is this gentleman brought up, is these companies are making products that there may not be a cure for if they weren't making these products, and that's often a key defense that's that is used during trial by a pharmaceutical drug or device company, is exactly that. Look, sometimes bad things happen. We're trying to do the best, we're trying to do the best we can. Look, these people, I'll get to that in a minute, but the counter to that is I understand that, and I suppose that the counter is I understand that, but you have to use the drug and device as it was approved, and you have to have full disclosure to the FDA, and I think that's where a lot of the disconnect comes. The second one's the plaintiff's in a bad health anyway. The best way I can liken this to, the Granny Flow case is a great example. One of the arguments we heard from the manufacturer is, well, yeah, maybe. Let's just assume you're right, that this was not formulated the right way or these people weren't trained. But at the end of the day, they're going to die anyways. I mean, they're 80-something, and, they're in bad health, they're in dialysis, and frankly, we're keeping them alive. And I say, okay, I understand that. But my response, I suppose, to that is, if government statistics show that a person lives to say a woman lives to age, I'm on average, I'm making this up, say 82 years old, and I shoot an 81-year-old woman in the head, I don't think that they're going to give me 1 year because, well, technically she would have only lived one more year. So that's my supposed response to that. So the next kind of piece is consequence of mass production is mass torts. That's just how things are made. It's mass production these days, and there's mass lawsuits. Otherwise, we'd be tied up for generations trying to get through some of these cases. The final piece, the FDA, EPA, the OCC is the Office of Comptroller Currency that regulates the banks. CFPB is the Consumer Financial Protection Bureau. At the end of the day, and I can say this for certain, the EPA and the FDA especially, I mean, their decision is based on what information is provided to them. A drug, for instance, is approved based on the testing as it's given to them. The FDA does not individually test. It doesn't go back and say, well, did you test for this? I guess it could go back and say, did you test for this or test for that? But it doesn't conduct its own studies. All it has to go on is what the pharmaceutical company provides to it. Just like in the EPA, for instance, all the EPA can go on is, they can do their own testing, but a lot of times they're given certain information. And same thing with the bank regulator and all these kind of things. And at the end of the day, it's a government agency with limited resources and accountability. And, to the extent that, there is a limit on, especially, what information may have been disclosed to the FDA when it decided to approve a drug or how it approved, and the later it comes out some of that stuff wasn't true or it's being used in an off-label manner. The FDA is not going to prosecute someone for that. So that's where I suppose your private counsel comes in. So let me do a quiz. So anybody know, what are some of the reasons for aggregating claims? You want to take a stab at that? Very good. Anything else? I think you hit the main point. All right, so next question is kind of what types of cases lend themselves to class as compared to mass treatment? I mean, I hope if I've done anything is maybe give you kind of a clue as to which ones are done as a class and which ones are done as a mass. So, again, on class kind of cases, you have kind of the same. Think of it. I always think of class as kind of a same across the board. Everything's got to be same. It can't be unique. It can't be individualized. And then and I think mass cases on the other hand, obviously there's just kind of disparate range of outcomes and things like that. So I'm through what I wanted to talk to you guys about. So I have all the time in the world. If you want to sit here and talk about something, or if you want to go home, go home. Okay.
I was curious, two things, just kind of procedure in your business. So how long does it take from the time Susie Smith walks in your door? Just a ballpark. Can you think of one time?
Sure.
From the time you learn about something till the time you cash a check.
Sure. So the question is how long does it take to do one of these cases?
I'm not talking about how long it would take me. I'm talking about you as a business. How long are you operating?
Oh.
You're operating with people doing discovery and doing research and so forth. How long does it take before you get paid for it?
Sure. So she's asking from a business lawyer standpoint, how long does it take to get paid? So I can give you a couple of examples. For instance, often we'll hear about a case, especially on the class and mass cases. These take a while, and we'll hear about a case. I can tell you that most class or mass cases, the lawyers front all the money on these. There is no people paying for the $1 million for the experts, and if you don't win, you're out. You just lose your money. And so the lawyers front all the money on these on a contingency basis, meaning if you win, we get a percentage of the pie, if you will. And so a lot of these cases, for instance, I can tell you one class litigation we had, I came to the firm, it had just started in 2009, and we are nowhere near resolution. So for 8 years, we have fronted every penny, all of our legal work. There's not been one dime that ever was paid to us for all of the work for that case. I can tell you on a pharmaceutical case that was recently resolved, it took about 6 years. And so between case to check. So they're not all the same. Every once in a while we get lucky, so, and move one quicker, but it takes a while. Yes?
How does it find? Do you track your hours and then check that way?
We do. It just depends on the kind of case, especially on class actions. Class action fee, most people don't do that. It's just not, you don't automatically get a fee. The class action fee has to be approved by the court. And so in order for you to get court approval of your fee, you have to write a fee petition, and the court says yay or nay, and the court may say no and reduce it. But yes, in order to tell them how much time you spent, you have to track it. Yeah. Yes, sir.
It really sounds like that the legal profession is taking away buyer beware. That doesn't exist anymore. Buyer beware. In other words, we're harmed in any way, shape, or form. It's not a case of buyer beware. It's a case of, well, I've been harmed somehow, so I'm going to figure out a way to litigate this so that I can be compensated. So that's almost being eliminated by the attorney.
Well, I see what you're saying, but I suppose my response to that is first of all, there are tons of things that happen on a daily basis to people. I read something one day. There are tons. I read something one day that the percentage of people who are in an injury or an accident, with a slip and fall car accident, that actually file suit is like 10%. It's very, very low. And and most products are made without any issue. I can tell you the other day I bought some Doritos. I love Doritos, and basically I didn't get Doritos. I got tortilla chips. They had no, so I wrote them an email and they sent me a couple of coupons for some free Doritos. So most 99.999% of transactions are dealt with in that manner. What you only hear about from the news, or because otherwise it's not very cool news that Seth Crompton got 2 free things of Cool Ranch Doritos, except to me. But no one in the world cares that I do. Now, if I use some device and I can't walk again, that's a little bit better of a story. So I think the news cycle, I suppose, kind of exasperates, I think, what you're saying. Because, for instance, most people really don't. I mean, there's people who live with, problems with decking, on construction products, problems with decking, problem with shingles, never do anything about it. Yeah, well, that might be one thing. And the other thing is disclosure, too. My biggest thing is if you knew something and you didn't disclose it and you wouldn't have bought it otherwise because of, had someone known that, they wouldn't have bought it. That's a little bit of a different issue than a buyer beware. Yes, ma'am.
Criminal case. Do you respond to criminal cases? You said earlier, didn't you, that you had worked for criminal cases?
No, I did corporate. I was on the corporate side. I did civil defense. I don't do criminal. You might have to ask Jen. She used to be a prosecutor. So if you have a criminal question, you got to ask her. I only know what some of my family members did and whether they went to jail for
back
it.
here when you get to.
Oh, yeah.
Tagging on with the one gentleman that said over there, I'm sitting here thinking, every day the products that I could buy, from shampoo to toilet paper, there could be an issue in a class action lawsuit depending upon if it harms me. And again, buyer beware. From building a house to a car to tires, I'm thinking to myself, there's nothing other than to stop living, and even the doctor, when I go to Walgreens, the prescription paper, please be sure to read the paperwork. Mm-hmm. And by the time you read it, it's like, what the hell am I taking it for?
Right.
And then on TV, the commercials come across here. It's like, who would even begin taking this medication if it's going to impair you in such a way that you're going to die?
Yeah, I mean, yeah.
It's like, holy.
I mean, but, you know, for the most part, again, as I mentioned earlier, for the most part, we're really talking about a small number of products really on the market overall that, you know, this happens to. And, you know, look, I mean, at the end of the day, you know, some products have, you know, that probably most of the things, if you think about it, you bought your whole life, you know, might have got a defective razor or something here or there, but, you know, I mean, it just threw it away and you got, you know, went on to the next one in the pack. So, you know, I agree with you that it sounds doom and gloom, and I certainly wasn't my intention to sound doom and gloom, but what I'm dealing with is, you know, as my dad says, when someone comes to see you, they're having a really terrible day. So, you know, and then that's what I deal with is the 0.01% of somebody's terrible day. Go ahead. I'll work my way back.
Our punitive rewards have a part of the rewards in class or manufacturing. Punitive.
Yeah, I mean, as a practical matter, not too many class cases actually get to trial. There's usually, some sort of a business resolution along the way. But sure, you can certainly ask for them. You know, they have to be allowed under the law because, again, the class action suits just all it is a procedural device to aggregate claims, and the claims all are based on what your standard causes of action: negligence, consumer fraud, and if they're allowed under the law, yes, you can get them. So,
is there a possibility? Well, with your advice basically all the time to be careful of the small print. But I have just been sitting thinking of, right, because one line can be a paragraph, and it's all cutting. But I maintain that if that was at the top, in bigger letters, then can we get down to what we're purchasing? Wouldn't that be more honest?
Yeah, you know, I mean, you know, it's just a matter of, you know, again, marketing decisions are made, and marketing decisions are made based on, is this going to cause less sales or more sales? And sometimes having really big print at the top of a can is not necessarily conducive to having more sales. So, I don't know. That's a business decision they make. There are certainly there have been some cases. We did an insurance case one time relating to how AAA worded some disclosures and kind of the way they were kind of rigging the fee structure a little bit on some of their products, and it wasn't really clear from the disclosure. And part of the resolution was, okay, if you're going to do this, you need to at least make people aware that you're doing it. So.
Tough luck then as you get older or bad eyesight. Where you can't make out the trip, but you want the thing and you just buy it.
Yeah, I don't know. I don't know how to answer that one. I mean, all right. I'm sorry. I'll get you next. No, go ahead. I'll get you.
What are your recommendations on reading disclosure things that might be pages long rather than in the product? You pick up a can and read it and say, oh my God, I want to use that.
Yeah, I mean, especially on the pharmaceutical stuff, I can tell you I certainly read that. I mean, obviously I do try to, Doritos aren't the healthiest option, but I do try to take care of myself to some extent and, reading some,
How much Cool Ranch taste did they promise on
right,
that?
Right.
Okay, I was wondering if there's ever any criminal charges that come out.
Sure.
Like
So,
Wells Fargo.
yeah.
Those is obvious fraud.
There's a lot of them. I mean, you think that one of the biggest financial frauds that everyone read about was the Bernie Madoff thing. Bernie Madoff is imprisoned, and so certainly yes. Does it happen very often? No, but it does happen. Yeah. Yes.
When you're discussing period, how do you get the corporation, especially police information to police sunshine law, or get a whistleblower to turn on?
So whistleblower does happen on occasion, but in theory, the rules of civil procedure allow you to ask for certain documents, and I suppose the in theory part of that is that they're supposed to be turned over to you. So that's kind of where the big fight, the lawyering itself comes in, is what's getting turned over, what's kind of objection, we don't want to turn this over and stuff like that. But the short answer is that the rules of civil procedure allow for allow for that to happen.
And
No, you
Seth,
guys
also
have-
early on, you can get the court to issue an order that they can't, the other side can't destroy.
Correct. So yeah, that's one thing we send with all of our big cases. It's called a preservation letter, and basically says, don't start wiping out your mainframe. We'll go in the back.
How do they get people to turn over documents? If I were a crooked business, or if I were going to get sued over something that I knew that was wrong and I didn't disclose it, I just wouldn't turn over the documents. So how do they get?
Yeah, the question is if you know there's some bad documents out there for your company, how are they forced to be turned over? In more recently, I suppose it's a little bit easy, not easier. It's certainly hard because you got to get through the programs and do it. But some of this is stored electronically and it doesn't get deleted or it doesn't go away. How it comes, in the old days of, how did they get documents from the 1960s saying, asbestos is bad? Eventually, there was enough discovery done, there was enough depositions taken, that finally after a while, someone probably somewhere in a deposition said, well, yeah, we did look at that in 1960. Okay, well, what would you do it at? We looked at it with the National Institute of Health in, New York in a conference. Okay, now we know we want those documents. So it's a very, very difficult process, and at the end of the day, if someone doesn't want to turn something over and they literally stuck it in the shredder, wouldn't be the first time, and it certainly makes things difficult to not, because I don't think we generally have the smoking gun document. Those are nearly impossible to get, but they do exist on occasion. But generally, I think those are kind of cloaked or kept back through various reasons, not necessarily nefarious. Some of them, legal strategy and technical reasons. So, do you have questions over there?
I just wanted to say, I just finished reading a book. I consider it not a class.
Okay, yeah. No. So
it's about the women that did the radioactive dials.
Oh, really?
And that's with bone cancer and possible confident. So the company knew.
Mm-hmm.
So I think that's the thing that I think is really part of a lot of these lawsuits is the fact that when you know that something's bad and let you do suffer all of this awful consequence and die as a result.
Yeah, and so the recommendation.
Gambling, because you have to be a gambler.
Right. So the recommendation was radium what? Radium Girls is apparently a good example of a mass tort you should all read. And generally what drives, when you hear a big verdict, a big number, in my experience, what has kind of driven that number is documents which demonstrate knowledge that wasn't disclosed that later, would have certainly changed someone's decision had they known that they might get, cancer or something from a product. So, anything else?
No, excuse me.
Yes, sir.
Is there a time limit on any of these suits?
Mm-hmm.
Is there a statute of limitation?
Yeah. Again, a class action is just a procedural device to aggregate claims, and mass action is just a bunch of personal injury claims. So, the same product, like if you were to, I give you, the guy who puts it's pretty gross, but he put it, his hand went through the pen press and smashed it as a product liability case. For, he has 5 years in Missouri, just like if you took a drug or device in Missouri and you were harmed from it, you have 5 years when you kind of figure it out. Other states have different. Illinois has 2 years. Michigan may have 3. Indiana has 2. So it's just state specific. Yeah.
A question came up the other day concerning a municipality, and underneath Senate Bill 5, that in 1965, the cities began attaching a fee to a warrant for failure to appear in court. Mm-hmm. Went back to 1965 when it was initiated through the court system. The arch defenders came in, reviewed it, and said this was an illegal fee going back to 1965 and now you must pay it back. The judgment came back to the city of $900,000. At this point here, the city had to allocate $900,000 for the judgment.
Right.
In their case, they had to notify all the defendants that they were overcharged, and then they had to refund them the $3. This is absolutely, to me, ludicrous that it passed the court audits, it's passed the attorney general, the state of Missouri auditors, and it's passed up the municipal auditors, and no one's ever checked that, and yet the residents, the citizens, are up to a $900,000 judgment on their back now. And there was no time limit. This is 1965, and it just happened underneath the arch defenders.
So yeah, so one way in which the statute of limitations is told or extended, for lack of a better phrase, is if there was, concealment, or there was, fraudulent concealment, or it was purposely not disclosed. And so I don't know much about that case, but what I'm guessing they argued was that that this wasn't there was some tolling kind of there, meaning this wasn't disclosed. And the second piece I assume that they argued was that, hey, you knew this was illegal. I'm making this up, but say you knew this was illegal on constitutional grounds, but you kept doing it, and there's no way the layperson wouldn't have any way of knowing this was illegal on a constitutional ground. So that's kind of how you deal with that.
All right, folks, I think we're pretty much out of time.
All right, thank you all.